This book project is the endgame of 12 years of pro-para litigation in the U.S. court system, and the product of sustained independent research geared at constructing a carve law model of global health governance using game theory. Now, a carve law model is simply a model of cause and explanation that, properly conceived, clarifies a complex state of affairs by employing a distinct precept. The complex state of affairs here is global health governance, understood as collaborative, transnational research and action for promoting health for all. It is my contention that Plato provided the key precept for global health governance in the Republic, namely the form of the good, albeit a riddle wrapped up in a mystery instead an enigma, which will be unraveled as we go along. For now, let's focus on the social theory of governance by identifying its key constituents. First and foremost, the life world, that is, our collective pool of intersubjective meaning and perception, comprised of an ideal superstructure and a material infrastructure, where communicative action and instrumental action take place respectively. Nested or embedded in this life world is the system, including the formal institutions of the state, whose strategic actions essentially consist in symbolic manipulation. Taking a cross-sectional view of the state, for example, reveals a system of political and administrative governance, which correspond more or less to systemic governance. Dotted, dotted lines reflect the extent of open versus closed government or negative versus positive liberty, where negative liberty is freedom from government coercion, and positive liberty is the freedom to participate in government. In light of what precedes, the problematic of governance in general and global health governance in particular comes down to state actors who make only a vain show of being guardians of the laws and of the Commonwealth, and non-state actors who shun or are excluded from the affairs of the state as private citizens, otherwise called idiots in classical Greek. If the state is the mind writ large against the sky, as Plato famously contends in this colloquy, it is not a stretch of the imagination to say that the international system is the mind writ large against the heavens. This table brings the matter to focus by summing up the three philosophical traditions proposed by the English School of International Relations, a school that also claims the mantle of liberal realism in the sense that philosophy can liberate the mind from nonsense using common sense. For the first time, this book project will demonstrate that these three philosophical traditions are in fact three aspects of one fundamental reality. Hobbes' Leviathan alludes to the power of God as told in the book of Job, a fact thoroughly traduced in academia. Grotius' law of war and peace speaks to how said power is construed and misconstrued, while Kant's metaphysical morals is a high resolution, notably where Kant identifies the paralogisms and antinomies of reason. Properly understood, a theist, deist, and atheist will be in complete agreement with Kant's metaphysical morals, which admits of no moral relativism. The key precept here, or in this understanding, is the coping stone of Plato's blueprint of philosophy, to which we now turn. In the Republic, Plato used three allegories: the allegory of the cave, the allegory of the divided line, and the allegory of the sun, to distinguish the world of appearances comprised of illusions and opinions from the intelligible world of forms, comprised of mathematical thinking and knowledge, the form of the good being the highest form of knowledge. It is often said, and wrongly so, that Aristotle rejected Plato's theory of forms. Saying that Aristotle rejected Plato's theory of forms is tantamount to saying that Aristotle rejected the syllogistic logic that he originated when he pointed out its pitfalls in his treatise on sophistical refutations. To be clear, syllogistic logic consists of two terms, a subject and its predicate, in which the predicate is either asserted or denied of the subject to constitute a categorical proposition. Of the 256 possible propositions, constituted by permutations and combinations of the universal and particular affirmative, or the universal and particular negative, only 24 are logically valid, 15 of which are said to be unconditionally valid, and 9 conditionally valid. The point is this: logical fallacies are so insidious and pervasive that even Aristotle saw fit to place ethos, appeal to good sense, above pathos, appeal to emotions, and logos, appeal to reason. Accordingly, Aristotle does not depart from the hierarchy that Plato established in the intelligible world of forms, where mathematical objects are subordinate to knowledge of the form of the good. Simply put, the whole, that is, the form of the good, is greater than the sum of its parts, that is, mathematical objects. And Descartes seized on this to the point of being generally recognized as the father of modern philosophy. Descartes' breakthrough is methodological. It is a synergy of logic, geometry, and algebra, taking the advantage of each and dispensing with their limitations. A process so successful in the development of analytic geometry as a forerunner or precursor of the scientific revolution. In Descartes' words, those long chains of reasoning, each of them simple and easy, that geometricians commonly use to attain their most difficult demonstrations, gave me occasion for imagining that all the things that fall within human knowledge follow one another in the same way, and that provided only that one abstain from accepting anything as true that is not true, and that one always maintains the order to be followed in deducing the one from the other, there is nothing so far distant that one cannot finally reach, nor so hidden that one cannot discover. Many a philosopher emphasizes methodic doubt, as the substance of Descartes' methodology, thus turning the starting block of modern philosophy into a stumbling block. As a matter of fact, Descartes' methodology consists of rules which are certain and easy, and such that whomsoever will observe them accurately will never assume what is false as true, or waste his mental efforts, but gradually and steadily advancing in knowledge, will attain a true understanding of all those things which lie within his powers. It is important to recall that Descartes received a formal education as a lawyer, and was especially awake to the need to dispense with sophistry and attune the vagaries of the law. In the words of Descartes, the multiplicity of laws often provides excuses for vices, so that a state is much better when, having but a few laws, its laws are strictly observed. So in place of the large number of rules of which logic is composed, I believed that the following 4 rules would be sufficient, provided I resolved not even once to fail to observe them. The 4 rules follow. First, to accept nothing as true that is not recognized by reason as clear and distinct as the demonstrations of geometry. Second, to analyze complex ideas by breaking them down into their simple constitutive elements, which reason can intuitively apprehend. And then thirdly, to reconstitute the simple elements, and fourth, make enumerations so complete and reviews so general that one might be assured that nothing was omitted. The essential point is that if we perfectly understand a problem, we must abstract from it every superfluous conception, reduce it to its simplest terms, and by means of an enumeration present a workable solution. Now, game theory, understood as the mathematical modeling of conflict and cooperation among intelligent, rational decision makers, gives us occasion to apply Descartes' methodology. The next few slides present the 3 forms of game theoretic representation in simple terms, then demonstrate their complex interactions in the endgame of actual case law. First, the normal strategic form of game theoretic representation, denoted pathos here because it presents a snafu with respects to goods. The structure and payoff matrix of the normal strategic form is well characterized in the products literature and games, so we need not dwell on them other than to underscore that they are pathological insofar as they involve fighting in the Hogdove game and backstabbing in the Prisoner's Dilemma game. While the normal strategic form is the staple of classical game theory, its originators, von Neumann and Morgenstern, emphatically noted in their seminal Theory of Games and Economic Behavior that classical game theory is thoroughly static, as it lacks, and I'm quoting here, an explicit treatment of the dynamics of rational deliberation. While rational persons create value in a world of meaning, the payoff in the normal strategic form game is fundamentally about minimizing maximum loss or maximizing minimum gains. Second, the so-called extensive form game representation, denoted ethos here because it presents relations of ideas and their ordering in terms of kin, networks, and groups. Here, classical game theory and the more dynamic evolutionary game theory are melded. This is a very busy slide, but the point here is quite simple. Omega is the action space of every possible outcome, including proposition A, evidence B, and their complements. Now, the joint probability of A and B, in other words, the Bayesian probability of a proposition A having the benefit of available evidence B, is also a function of expected utility in the face of costs, as formalized by Martin Nowak in his 5 Rules for the Evolution of Cooperation, where changing the relation of facts and or views changes expectations. As Charles Darwin, the father of the theory of evolution, famously noted, false facts are injurious to the progress of science, but false views do little harm, for everyone takes a salutary pleasure in proving their falseness. As it were, lawyers who cobble together a few rules, statutes, and precedents to raise factoids to the level of facts are condemned by their false views. With this in mind, we can engage in the third and final form of game theoretic representation. The characteristic function form, denoted logos here, draws upon the 3 arts or sciences that informed Descartes' methodology: syllogistic logic, geometry, and algebra. The geometry here is intuitive, and it's not, or rather, does not exercise one's understanding whilst exhausting one's imagination. Clearly, political and administrative governance are subsets of systemic governance. The algebra is also intuitive and is not so governed by laws and symbols that encumber one's mind rather than cultivate it. Where B is an element of A, there is no problem to speak of. But where B is not an element of A, sovereign power attaches until A and B are held in a divine proportion. The key here is the notion of transferable utility, understood as the coherence of wants and beliefs. And the term characteristic function is equivalent in meaning to utility function, understood as a system of ordered preferences involving the following alternatives: minimax, which is minimizing maximum loss; maximum, maximizing minimum gains; or creating value in a world of meaning. Turning to actual case law, this series of cases derive from the same nucleus of facts and are illustrative of court actions as a hawk and dove or a prisoner's dilemma game embedded in a sovereign constituency coordination game. While courts exercise sovereign power, it is a logical fallacy to suppose that such is necessarily the case. Sometimes, as here, court actions are hawk and dove games or prisoners' dilemmas, where lawyers and judges become prisoners of the law engaged, as it were, in minimax and maximin calculus. Indeed, despite years of litigation, judgments, and opinions, the gravamen of the action remains intact, and no sovereign power has abridged, much less abrogated, the author's moral rights to the attribution and integrity of his original research publication, nor the author's rights on a research grant funded by the U.S. National Institute of Health, nor the author's moral right to the timely attribution of his Master of Arts Practical and International Administration. These unassailable facts are papered over and drawn out in court in a manner consistent with C.S. Lewis's observation in the Screwtape Letters, where the senior tempter, Screwtape, advises his understudy, Wormwood, that the safest road to hell is the gradual one, the gentle slope, the soft underfoot, without sudden turnings, without milestones, and without signposts. In a related action, Wormwood gaffes, and Screwtape gives up the ghost. Here, U-Haul International allegedly engaged in a range of malicious, unfair, and deceptive trade practices, including fraud and conversion, amongst a litany of violations alleged in a plethora of lawsuits and myriads of consumer complaints available online. Facts uncontrovertibly established here by U-Haul's very own posted contract notes. Citing Andela versus University of Miami as substantive case law, the lower court judge, Wormwood here, in commotion with U-Haul's College of Lawyers, dismissed the verified complaint, ultra vires, while the matter was properly before the higher court, arguing inter alia that Andela would be unable to show that his appeal involves non-frivolous issues. Unwittingly, Wormwood had lowered the threshold for demonstrating fraud upon the court. Here is a patent example of a logical fallacy dress-stopped in legalese and masquerading as the law. The major premise, that is fraud by U-Haul, is substituted for case law derived through fraud upon the court. The minor premise being that Andela has been unable to clear the high threshold for demonstrating fraud upon the court. Premise is gainsaid by the appellate court. Stated more directly, the higher court found that the lower court's order dismissing the verified complaint was fraud upon the court, so the action was returned to the original position, to paraphrase John Rawls. Fraud upon the court is deceptively simple and is best captured by the classic double-slit experiment, the plaintiff and the defendant being the two slits through which a plane wave travels to form an interference pattern of alternating bright constructive and dark destructive bands. Removing the double slit, which is the proper function of justice, and which obtains from following Descartes' four rules, removes the interference pattern, so that a judge who rules conclusively on a case, such that the interference patterns persist, is either ignorant, inept, or a fraud. To be clear, the function of a judge is to interpret the law, and this admits of no ambivalent constructions or strained inferences, on pain of proving too much about causation. Speaking of causation, the ancients spoke of four causes, namely the material, formal, efficient, and final cause. On cause inspection, the four causes are instantiations of one cause, the first cause, just like matter and energy are one and the same thing under the standard model. Now, paradigmatic of the material/formal cause, this Covenant law model contrasts diamond and graphite, both again of which are fundamentally one and the same substance, carbon, but with distinct modes and attributes on account of fundamental differences in the formal arrangement. Diamond being transparently clear and connected in its construction as opposed to graphite. The material/formal cause, as illustrated here, speaks for itself and equally speaks to the efficient and final cause. Now, turning to the mathematical notations in this Covenant law model, let us first recognize and acknowledge the importance of mathematical formalism. George Orwell's famous essay, Politics and the English Language, underscored the causal connection between politics and the debasement of our natural language by sophistry that's designed to make lies sound truthful and give an appearance of solidity to pure wind. Like Orwell, Hobbes was critical of the debasement of natural language, and his epigrammatic discussion of reason and science, Leviathan chapter 5, is remarkably clear on this matter. Like here, Hobbes reduced reasoning to two operations, addition and subtraction, both of which are vectors with magnitude and direction. Multiplication and division being akin to addition and subtraction, except that they are scalars with magnitude and no direction. So the notations here reflect this: a war of position, positive for constructive, negative for deconstructive, and a war of maneuver, denoted by the golden mean or the divine proportion, in an infinite series, a series being simply the operation of adding an infinite number of quantities one after another in keeping with a simple rule, the golden rule. As a moral precept, The golden rule, that is, doing unto others as you will have done unto yourself, equates to the golden mean, or the divine proportion, which can be formally expressed by the operation n plus 1 divided by n, where n is any natural or counting number, as opposed to an imaginary or complex number. Case in point, the ratio of contiguous numbers in a Fibonacci series being the most efficient arithmetic or geometric arrangement contrived by nature, tends to the golden mean as n approaches infinity. And in fact, the golden rule undergirds all types of law: ceremonial law, moral law, judicial law, social compact law, or otherwise. By way of contrast, all court judgments and opinions germane to this book project violate the golden rule and run circles around causation, by an operation elegantly captured in Euler's identity, which is represented here on the Cartesian coordinate system, except that the x-axis is real and the y-axis is imaginary. To be sure, legal fictions are like imaginary units, so that what is properly a sovereign constituency coordination game becomes an anti-coordination game. The tour de force of this book project comes down to the fact that all legal fictions or imaginary units attached to the concept of sovereignty have been made plain. To the extent that this book project clarifies the logic of sovereignty and its proper exercise in the Commonwealth, it will be increasingly adopted as the gold standard. To participate in this book project, please join the campaign running on Kickstarter from October 10th to November 15th, 2019. A working paper of this project, 200 pages long per the publishing industry standards, will be available on the Social Science Research Network on October 31st, 2019. In the meantime, a transcript of this presentation can be accessed on the Social Science Research Network. Thank you.